Thank you, Mr President. I rise as one of two Greens who will be speaking to the COVID-19 Emergency Response Further Measurements Amendment Bill today, as other members of this council have outlined, although I note with the exception of a government spokesperson on this bill, we are facing another rushed piece of legislation. For those playing at home, we were offered briefings on this bill sight unseen, either on Monday or Tuesday. Most members of the crossbench attended a briefing on Tuesday morning, just before, of course, the parliamentary week commenced, and here we are 2 days later debating the bill. The bill has ostensibly claimed to be putting into place some of the national decrees, but it has a range of other measures as well that and certainly it's definitely an omnibus bill. I know my colleague, the Honourable Mark Parnell, will be discussing at length, no doubt, commercial leases and those aspects. So I have focused on my parts of the portfolio in the bill and have raised some concerns in the briefing about, under Schedule 2, the provision under 25A titled Removal of Children, which states, 25A, removal of children, 1, without derogating from section 25, an authorised officer may, for the purposes of ensuring compliance with any direction under that section, remove a child from any premises, place, vehicle or vessel to a place of residence of the child or to a hospital or quarantine facility, as the authorised officer thinks fit, brackets, and may in doing so use such force as is reasonably necessary, in brackets. 2, in this section, child means a person under 18 years of age. Place of residence includes, in the case of a child who is in the custody or under the guardianship of the Chief Executive under a Children and Young People Safety Act 2017, any place directed by that Chief Executive. My initial question was, why are we doing this? What is the need for the police to have additional powers to remove a child under the age of 18? To that, in the response on Tuesday morning and followed up in writing, was the police want it. The police have asked for this and they want it. So the following question was, why do they want it? What do they want to do? How do they propose to implement this? And what is the need for this new measure that has been identified under the pandemic? To date, we're still waiting for why. Certainly, I also did ask, as the Honourable Connie Benares mentioned, who's been consulted with regards to this particular provision. I was told SAPOL was consulted, which is unsurprising given they want it. Certainly, that consultation, one would have imagined the question might have been asked, why do they want it? But so far we've not got that level of detail, that not really substantial level of detail that one would imagine that question would have been asked far earlier in the process than at a crossbench briefing on Tuesday morning. We were also told, though, that the Guardian and the Children's Commissioner have been consulted about this provision. So my first question to the government is, can they please provide the response from that consultation process, because as yet we have not seen that. A group that was not consulted that I spoke to this morning is YACSA, the Youth Affairs Council of South Australia. And their immediate concern was, well, as we've been raising under this pandemic, children often aren't safe at home. Children are often not in their place of residence because there's violence in their family home or sexual assault and abuse. I would like the government to respond as to how they've accounted for those concerns raised by YACSA and to explain why they didn't talk to YACSA about this particular provision. Certainly, as somebody who grew up in a family where the home was not safe, where under this pandemic, if I was still a teenager, I would have my physical safety at risk right now from provisions such as this. Is the government really purporting that a child's safety is to be put at risk by enabling excessive police powers to remove them back to a place of residence which may well not be a safe place. Further questions that were put on notice to the government we'll cover when we get to that particular amendment. I note that they have been circulated in writing, and I hope that they've also been circulated to the Labor members as well as the crossbench in terms of the response to further questions on that police removal power. But YACSA also raised quite rightly, and why is then the prescribed precinct power not adequate if, for example, as I suggested on Tuesday, perhaps the government and the police are concerned perhaps about skate parks or gatherings outside schools after school, or at the Rundle Mall's balls outside the newly opening shops. Perhaps this is the issue that we're seeking to remedy here. In terms of the powers, one assumes that they're with regards to gatherings, but if the government could clarify that, because it certainly hasn't been made clear to date, what exact need the police have to remove children. Is it only from public places? Has some other need been identified? And if this is pretty much a playground, skate park, Burnside pump track type of provision, then where has it been proven that in fact these children are gathering in dangerous numbers? I note that in schools we don't mind children gathering without social distancing. And I note that as they leave schools, they will be gathering in large numbers to catch the bus home or the train, possibly to get on the Gawler line, and again, possibly to break the directions on social distancing and gathering through no fault of their own. There has been no explanation why suddenly the police need these extraordinary powers applied to children, and for the government to bring this before us in a rushed way with no consultation that they provided other than the police want it is not only inadequate, it is reprehensible. I have sought to delete that clause in an amendment to this bill and say to the government, if it is necessary, then bring it back in 3 weeks' time with the appropriate consultation done, with the evidence that shows it is required, and then we can have a reasonable and rational discussion with the government in this place, and I'm sure that all members would facilitate that. But don't have a lend of this parliament by rushing this sort of legislation through when you haven't identified a clear need for it. Another area that I have some questions for the government and would like to highlight today is the Human Biosecurity Emergency Declaration impact in the South Australian community, and with particular attention to Davenport community. Davenport Aboriginal community is just a couple of kilometres outside Port Augusta. Both myself and the Honourable Kayam Ma, in a previous incarnation of this debate, in one of those other rushed bills, raised our concerns that Davenport community were not consulted before coming under the Biosecurity Act and the extreme provisions of restriction that entails. So imagine if in the suburb of Burnside suddenly people put up fences and there was a penalty of $63,000 if you went to the wrong side of the street, but nobody had even bothered to tell you that this was going to happen. You woke up one day to have bollards and a boom gate and 24/7 patrols at the end of your street, and no consultation was done to find out whether or not you needed to get your kids to the other side of that road to go to school, whether you had health needs, whether you had a heart condition, whether you needed dialysis, how you were going to get food from the local grocer, because on that community there was no school, there is no store, and there is no ongoing health services. So it was a very different community to that, for example, of the APY, which is far more self-contained. But what was seriously concerning was the lack of consultation with the residents who live in that community about their day-to-day needs and their day-to-day lives. I'm very pleased to see that the Davenport Community Council has actually lifted the restrictions and requested to be removed from the Biosecurity Act, and that they posted on the 12th of May, on Tuesday, that until they have official notification from the state government that while the Biosecurity Act has been requested to be lifted, the community continues to remain closed until we have that certainty. So my second question for government, and I have flagged this with the Minister for Health and Wellbeing, so it is not unexpected, is to outline what process applies now. My understanding is that the state government now has to contact the Federal Minister for Health, Greg Hunt, and make a request. And I note that already 2 communities in South Australia had successfully removed themselves from the Biosecurity Act. So it's not that this is unprecedented. In fact, this will be the 3rd community to remove themselves from the Biosecurity Act. But where is that process? Has the state government contacted the Federal Minister for Health? How long will the approval take for that federal determination to be made? Because at the moment, Davenport residents who had written petitions, who had certainly in their many numbers from many families, not just one family, but many families, expressed a range of concerns about how they were to access the basics of life, even to the point that, you know, they couldn't get their mail, let alone food, education, health services, or attend their jobs. In fact, I know of at least 2 community members who have lost their jobs as a result of this particular restriction being imposed from on high above them without consultation by the Community Council agreeing with the state government's request. So if the government could outline where that process is up to and put on the record for the community residents of Davenport who are now wondering whether or not they're subject to a $63,000 fine if they leave or enter their community under the inappropriate provisions that applied just a week ago. On that, it has been deeply disappointing that there's not lines of communication that are made very clear by government, and I briefly addressed this yesterday in my matter of interest speech. But I've been contacted by various human rights groups, including the Human Rights Law Centre based in Sydney, because they are concerned about some of the South Australian directions or lack of directions coming from the state coordinator. In other states, a contact detail for the state coordinator or their equivalent is readily available. But looking on our websites, not only is there no direct contact details for the state coordinator available on all of the sa.gov.au COVID websites, when I rang the COVID hotline last week, after some great confusion and being told I should look at the website, and then the person looking at the website themselves and going, "Oh yeah, you're right, not on there," I was told to ring 131 444 because that's the non-emergency police number, and of course the Police Commissioner is our state coordinator. This is entirely unacceptable. I note that when I made that point, it was then suggested to me that I perhaps contact the Police Minister, Corey Wingard. I found this also an unacceptable proposition. Then the manager took on the call and promised me that she would escalate this to the group, the committee, that looks at these issues that are addressed with the COVID hotline, and that my problem, my issue would be taken with urgency to that committee and I would be contacted. I gave my mobile phone number. I'm still waiting for a contact detail for the state coordinator to raise concerns with his directions. There is no accountability measures being put in place here, and I note at points that the website itself had broken links to the absolute basics, to definitions, for example, of what was deemed to be essential. And given we're now in a world where essential looms large on our lives in terms of our movements and our activities, the fact that when you clicked on the link for the website and couldn't see what was deemed essential should be ringing alarm bells for this government about how well they are actually implementing their emergency response. I don't doubt that people are working incredibly hard, But we haven't got the same level of scrutiny happening that the New South Wales government ensured and has put in place. We haven't got the same level of accountability that other states have implemented. And I really think that if this government, and as the Leader of the Opposition noted, I think this is the 6th bill, but certainly the 3rd rushed bill that we've seen. If we haven't got those levels of accountability and transparency, then really our patience and our trust will start to wear very thin. And those basics need to be in place to ensure that these extraordinary powers that we keep being asked to provide for, that already have been approved. In fact, the last piece of legislation allowed the suspension of any particular law of this state. So, in fact, why they're not being done in a more transparent way through directions is certainly a question that begs to be answered. But our patience is wearing thin. What is the purpose that police need to remove a child? That has not been established or responded to. I look forward to not fulsome answers, because people keep misusing the word fulsome in this and the other place, but actually frank answers to that question, honest and transparent and truthful answers to that question, and a response as to why it's not accommodated for in other pieces of legislation that already apply and why it is necessary. It is the most basic question a parliament can ask when a government introduces a law. Why are we doing this? And the answer should be provided. With that, I look forward to the committee stage. I certainly have significant concerns that we are not engaging in good practice with lawmaking in this place. And I note that we're rushing this bill through this week because, in fact, just last week the government issued a new sitting schedule. So we've put this upon ourselves by now having a longer period of time between this sitting week and the next. If this bill was so necessary, why did we not keep the additional sitting weeks that were to come?